Welcome everyone who's joining us. We're going to give everyone just a few minutes to make sure that we've got everybody who wants to join us on board and out of the waiting room. We'll get started in just a minute. All right, we're going to go ahead and get started. Welcome everyone. Appreciate you making time on a beautiful evening here in Idaho. And for those of you who are not from Idaho, it's beautiful here. So being in front of a screen may not be where you want to be, but we are happy that you're joining us for this very important topic. This is a special event that we're doing in conjunction with the IMA for IMA members so that they can understand a little bit more about how the Dobbs decision is impacting care in the state of Idaho. And with me today are my colleagues Hannah and Hannah. Caitlin, you're I don't know if you could change your name or not, but it says Hannah as well. So if you can change your there we go, perfect. All right, so Hannah and Caitlin have joined us. You're in the right place if you want to know the law and what you'll need to do to provide ethical care for your patients who are requesting medical care that is in regards to abortions. Dobbs has changed a lot and of how this is dealt with, and Hannah and Caitlin have both been spending a tremendous amount of time getting to know how that's going to be impacting care. So what we'll cover today is some background on the Dobbs decision itself, a timeline of relevant abortion laws and the decision, Idaho laws and definitions, the No Public Funds for Abortion Act, and what to do next. And then we will have some time for questions, but as Caitlin and Hannah will probably tell you, they would love to have you type questions as we go along. They'll be monitoring the typed questions and then we'll weave their answers into the presentation as they go along. I'm gonna introduce myself first. I am Luke Malek. I'm one of the founders of Smith Malek Attorneys, a law firm that has offices in Coeur d'Alene, Boise, and Spokane. And my practices really revolve around healthcare as well. I also do some business law. And you can see my quote there: as a business owner and healthcare advocate, I'm passionate about making sure that our healthcare organizations have resources they need to serve our communities effectively. And it really is my honor to be here with my colleagues today who are working on this issue and many issues impacting healthcare on a regular basis, starting with Caitlin O'Brien. Caitlin, do you mind taking a minute and introducing yourself?
Sure. Thanks, Luke. My name is Caitlin O'Brien. I'm an attorney at Smith Malek. My practice is 90% healthcare. I work with many different federally qualified health centers and physician practice groups across Washington, Idaho, and expanding to other states. I also do a little bit of business law and some telecommunications work sometimes. My quote on here is, "Healthcare is my passion. I feel so grateful every day to be able to apply my law degree in a way that so directly benefits our community." And I really feel proud and humbled that in the work that we do, we really help create access to healthcare, especially for those that wouldn't necessarily otherwise have it. So it feels like we're actually doing good in the world and not just working for the man all the time.
Thank you, Caitlin. Hannah, do you mind taking a minute introducing yourself?
Sure, thank you. My name is Hannah Andazola. I'm down in our Boise office. My background was in healthcare before attending law school. I have a master's of health science from Boise State with an emphasis in leadership. I went into law knowing that I was passionate about healthcare and wanted to practice healthcare law, and feel really grateful for what I get to do every day. So my quote is, "I'm passionate about healthcare law because it's a field that is ever changing and presents interesting legal challenges while allowing me to support organizations that serve our community." I feel so lucky to have a career that's challenging and keeps me on my toes, but also, like Caitlin said, really feels like we're contributing to the community and helping provide good access to care.
Thank you, Hannah and Caitlin. And a little bit about our firm. We are a law firm. As I mentioned, we have offices in Spokane, Coeur d'Alene, and Boise. We serve Idaho, Washington, Oregon, and we will be serving Utah soon. And we consider ourselves a business firm. And like I said, we do a lot of healthcare, as you can tell from talking to Hannah and Caitlin here, but we also do real estate, business transactions, and litigation as well. And with that, we're going to dive right into it. But I do want to say there was a correction there. There's a Q&A function. So if you can use that Q&A function rather than the chat to ask questions, that'll make it easier for Hannah and Caitlin to see your questions as they go through the content. So I apologize for misspeaking there, but please use the Q&A function and do ask questions as we go along. And with that, Caitlin, do you mind kicking us off, just giving us a little bit of background on Dobbs versus Jackson?
Sure. By now, I'm sure most of you, if not all of you, have heard of the Dobbs case. It is the recent Supreme Court case that came out that has changed the landscape for abortion law in the United States. So in 2018, Mississippi state, there was a law that came out that banned most abortion operations after the first 15 weeks of pregnancy. And the Supreme Court, it was challenged and stayed, and the Supreme Court of the United States recently on June 24th ruled in their slip opinion that an abortion was not a constitutional right, and that individual states now have the authority to regulate access to abortion services.
Great. And so we have did I interrupt you? I'm sorry.
That's just, I mean, that's the case. The state of Mississippi had one abortion provider, and that was the Jackson Women's Health Organization, and they sued on that law that Mississippi passed in 2018. So that went up through the rankings of the court and got to the Supreme Court, which then obviously we just said overturned Roe v. Wade and the subsequent case Planned Parenthood v. Casey, and stated that abortion was not a constitutional right under the 14th Amendment.
Great.
So we put together a timeline, which is then on the next slide, of what all that means. And Hannah, do you want to describe the timeline?
Sure. So we started back in April of 2022, which is when the Idaho Supreme Court stayed the enforcement of Senate Bill 1309, which you probably know is the fetal heartbeat bill. The Supreme Court granted Planned Parenthood's petition for challenging that law. So then on the 24th of June, the Supreme Court of the United States released the opinion in Dobbs that you're all familiar with that we're talking about tonight. On June 27th, Planned Parenthood filed a second suit challenging the trigger law, which is the other law that I'm sure you've heard about that we'll be discussing tonight. So that law will go into effect 30 days after SCOTUS releases the official judgment in Dobbs, which will likely happen at the end of July. So 30 days after that would be when it'd go into effect. The Idaho Supreme Court is hearing oral arguments on both of those laws on August 3rd. And then, like I mentioned, 30 days after the Supreme Court of the United States issues an official judgment in the Dobbs case, the trigger law would go into effect if nothing changes at a state level following the oral arguments on the 3rd.
And I just wanted, there's already a question real quick about the Dobbs case. So clarification on the Dobbs case, that was so it was the Women's Health Clinic challenged the law that Mississippi passed in 2018 that banned abortions after 15 weeks. So they challenged that, saying they couldn't do that. They couldn't ban abortions after 15 weeks because of the then current precedent under Planned Parenthood v. Casey, which was that you couldn't ban abortions before fetal viability. Roughly what at that time it was, at the time Planned Parenthood v. Casey came out, I think it was 24 weeks. Is that right, Hannah?
Yeah, I believe so.
Yeah, okay. Hopefully that clears that up. Okay,
excellent.
Next.
So we're going to move on to Idaho laws and definitions. Is that right?
Yep. So like we discussed, there's Senate Bill 1309, Senate Bill 1385, which is the bill that ended up being the trigger law, so 18622, Idaho Code 18617, and then we're going to talk about a few other Idaho statutes that are not necessarily new, but good statutes related to abortion to be aware of.
So we'll start with Senate Bill 1309. So there's, like Hannah said, there's two big ones that we're going to talk about tonight. Senate Bill 1309, which was passed this year, and then Senate Bill 1385, which was our trigger law, which was passed 2 years ago. They don't really work well in conjunction with each other, but the Senate Bill 1309 is civil liability for providers. Senate Bill 1385 is criminal liability for providers. So first, 1309. This bill bans all abortions in Idaho after a fetal heartbeat has been detected, with very limited exceptions. So the definition of abortion for this bill, sorry, my slides are a little bit out of order in how I printed them. Hannah, do you have the definition of abortion for that one?
I'll jump in. So under this bill, abortion means the use of any means to intentionally terminate the clinically diagnosable pregnancy of a woman with knowledge that the termination by those means will, with reasonable likelihood, cause the death of the unborn child, except that for the purposes of this chapter, abortion does not mean the use of an intrauterine device or birth control pill to inhibit or prevent ovulation, fertilization, or the implantation of a fertilized ovum within the uterus.
Right. And so there are three exceptions to this rule for aborting a fetus after the fetal heartbeat has been detected. That is medical emergency, rape, and incest. And fetal heartbeat means the embryonic or fetal cardiac activity or steady or repetitive rhythmic contraction of the fetal heart within the gestational sac. Medical emergency, as an exception, means a condition that within the reasonable medical judgment so complicates the medical condition of a pregnant woman as to necessitate immediate action or immediate abortion of her pregnancy to avert her death, or for which the delay will create a serious risk of substantial and irreversible impairment of a major bodily function. And this is important to distinguish for Senate Bill 1309. It's medical emergencies. It's not just death of the mother. So technically, if a woman was going to lose all of her reproductive organs if an abortion wasn't performed, then that would potentially be an exception to the abortion ban. And again, and then also if the mother's life was at risk. Rape or incest are also exceptions to the rule, but there must be a filed police report or handed to the physician in order for the physician or provider to perform the abortion. Is there any questions on 1309?
I think we do have one question there.
So we'll get into other statutes towards the end of the presentation.
Yeah.
The question asks about other pre-row laws to be aware of. We'll discuss that.
There's a question.
So the mother's life is at risk. All it says is that it necessitates whatever her medical condition is, it complicates her condition as to necessitate immediate abortion to avert her death. So like an ectopic pregnancy that got to a point where if it wasn't aborted, then the mother could bleed out. Or if the mother became septic or had some kind of uterine infection that would cause the mother to die, the fetus needed to be aborted in order to avert that. Those are the kind of instances we think they're talking about. However, it's not written super clear.
Yeah, it also includes, it says, or for which a delay will create a serious risk of substantial or irreversible impairment of a major bodily function. So we've interpreted that to mean like if it would require the woman to have a hysterectomy or something like that, that it would probably qualify under this.
And then another question, can the woman file a police report at the time she's seen for the medical help? I don't think that's how it works. My understanding is that it has to be done prior to. But we'll get to that at the next, we'll talk about that further with 1385. Well, do we have to wait till it gets to the point where we know the condition is dangerous condition incompatible with life? Yes. So does the woman's condition have to be so imminent that or so serious that her death is imminent? That's how it apparently reads. It's not that it could happen in the future, that it's 50-50. It's that her life is in jeopardy now. So and this is all going to be about, how you chart or how you document the need for the abortion. That's going to be what it really comes down to. And would another medical professional with your skill and training reasonably have done the same, have aborted the fetus in the same condition or in the same circumstances that you did? It's similar, just like a medical malpractice case. Another question, can we diagnose an ectopic and then have to wait for to rupture? I would follow what your standard of practice is. Is that what you would normally do? I've been told by numerous providers at this point that an ectopic pregnancy is always life-threatening. And if that's what the medical literature says and all your training is, then I would go with that. Let's start talking about 1385, because I think we'll talk through some more definitions, then we can get to some more questions.
Sure. So the definitions that are applicable to Senate Bill 1385 include abortion. And under this bill, abortion means the use of any means to intentionally terminate the clinically diagnosable pregnancy of a woman with knowledge that the termination by those means will, with reasonable likelihood, cause the death of the unborn child, except that for the purposes of this chapter, abortion shall not mean the use of an intrauterine device or birth control pill to inhibit or prevent ovulation, fertilization, or the implantation of the fertilized ovum. So the same as the other bill. Fetus and unborn child mean an individual organism of the species Homo sapiens from fertilization to live birth. And pregnant and pregnancy means the condition of having a developing fetus in the body and commences with fertilization. So as you can tell, there's a lot of emphasis on fertilization being when that starts.
Right, and this is the criminal statute, right? So this criminalizes abortion at any point. It's not once a heartbeat is detected, it's at any point, unless you meet the exception. And the penalties are, it becomes a felony to provide an abortion to an individual, and it's punishable by at least 2 years in prison, but no more than 5. And your professional license will be suspended with a minimum of 6 months, suspended for 6 months, which I don't really understand, because if you're in prison for 2 years, probably not practicing medicine anyway. But and that for your first offense, and then second offense, it's permanently revoked in the state of Idaho.
So the exceptions under 1385 are a little bit stricter than 1309. So the abortion was necessary to prevent the death of the pregnant woman. And it specifies that just because the physician believes the woman might harm herself, that doesn't qualify as necessary to prevent the death of the pregnant woman. So mental health concerns don't rise to the level required under this bill. Similar to 1309, if the woman has reported the act of rape or incest to law enforcement and provides a copy of that report to the physician who's going to perform the abortion. And similar, the physician must, in their good faith medical judgment and based on the facts that are known to them at that time, perform the abortion in a way that provides the best opportunity for the unborn child to survive, unless the physician thinks that terminating the pregnancy in that manner would pose a greater risk to the pregnant woman of death. So a little confusing, because generally abortions are not performed trying to save the life of the child in that situation.
Right. And the only way the only thing we could really think of in this realm would be if it's an ectopic pregnancy, and for some reason, I know they don't get to 20 weeks, but if the pregnancy went past the point of somehow viability, the provider would have to try to save the fetus while performing the abortion. If it's aborted live, I guess. Or if the woman got some kind of infection later on in pregnancy that meant she had to deliver too early. Those were the only real instances where it would make sense, because prior to viability, there really is no opportunity to keep the child living. So anyway, again, I don't think that these were written by people with medical training, and so the definitions aren't clear for providers.
So we have a question. Could it be that you're found not guilty in court, but the medical board could still suspend your license? And the way it's written, it's not clear. It doesn't really say one way or the other. So I would think that the medical board would probably defer if you're found not guilty and it's found to have been, fit one of the exceptions, but it's not written in a way that's super clear on that.
And another question, a good question came up. So it's important to note that in Idaho, under the Idaho rules, there are no exceptions to the abortion rule for fetal anomalies or any kind of genetic issue that was incompatible, so making the fetus incompatible with life, or any brain malformation that made the fetus incompatible with life. It is not a reason to terminate under our new abortion laws. Additionally, there is no exceptions for embryo selection in the IVF process. So if you've implanted more than one embryo, and normally you would select the best one had chances of surviving, you can no longer do that under the rules if it's already implanted. So important to note. I think that's all the questions on there for now. Next, we talk about 18.617. Here we go. 18.617 is discusses abortifacient drugs and medical or chemical abortions. It's specifically an abortifacient drug is I'm not good at pronouncing these, misoprostol, or any other chemical or drug dispensed with the intent of causing an abortion, as defined in 18.604, which is the definition that we've been using about abortions, right? So this is not IUDs, it's not birth control pills, it's not Plan B for now, most likely, with the caveat that they don't call that one out. But it's a medication that's used to expel an embryo from the body, or a fetus, I guess. But under this section, it specifically states that the legislature, or that nothing in this definition of the drug shall apply when used to treat an ectopic pregnancy, or nothing in this rule. So under 18.617, you can use those drugs to treat an ectopic pregnancy, which would seem to show that the legislature at one point had the intent to treat ectopic pregnancies as different and not as abortions.
I think,
again, this was written before. Go ahead, Hannah.
Oh, I was just going to say, I think it's important to note that this was written before the other two, so it could change going forward.
There's a question about selective reductions when twin pregnancies. Again, fetal viability is not in play in the either 1309 or 1385. It is strictly on the life of the mother, rape, and incest. Other states have laws, like Utah has exceptions for fetal viability, but not Idaho, not now. Can you tell a patient where to access a prescription? We'll get to that. We'll have that. We have that slide coming up. Okay, any other thoughts, Hannah, on your 18.6.17?
Nope, I think that is a good high-level overview.
Okay.
So,
Let's-
yeah, if we go to the next slide. So the additional statutes that we mentioned at the beginning of the presentation we're going to discuss are Idaho Code 18204, Idaho Code 399504, and Idaho Code 188702. So 18204 has come up with a lot of the discussion about whether or not making out-of-state referrals is going to become an issue. And as Idaho's bills are written right now, they don't seem to prohibit out-of-state referrals. We've received a question though about 18204, which is the general law in Idaho that makes it a crime to aid and abet in the commission of a crime, basically. So if you're helping someone commit a crime, but because there's nothing in the bills right now that prohibits you from referring, and because you'd be referring to a state where the abortion would not be a crime, we don't think that this applies at this point.
If you're referring to another abortion provider in Idaho, that could be an issue. But if you're referring out of state, right? Because Idaho doesn't have jurisdiction over physicians in other states. So if it's not a crime in Washington or Oregon to provide an abortion and you're referring to a physician over there, you're not aiding and abetting in a crime.
So 399504 is called the Abortion Complications Reporting Act, and it requires providers or facilities in hospitals to file a written report with the Department of Health regarding every woman who comes under their care for treatment for an abortion complication.
And it specifically lists the way it gets around HIPAA is you're not sharing PHI with Department of Health and Welfare. You're just sharing the age of the female, how many times she's been pregnant. But one thing to note is that you're required to share who the abortion provider was and what facility it happened at.
Yeah, and it's a pretty extensive list of complications. So the one that stood out to me when reading it is that if a woman comes to seek treatment for any like psychological or emotional condition that resulted from having an abortion, like depression or anxiety, that's on the list of complications that must be reported. So again, like Caitlin said, you're not reporting her name, but it's a pretty extensive list of information that you do have to report, like age, race, state and county of residence, number of pregnancies, number of live births, number of previous abortions, the date of the abortion, the gestation age, the provider, it kind of goes on and on. So they collect a lot of information.
And it's not a may report, this is a shall report. So if this is like in the behavioral health realm too, right? If they come to their therapist and they're having anxiety or shame or guilt for having an abortion, they provide any provider that's dealing with these post-abortion issues is supposed to report. We didn't know this existed until 2 weeks ago. And actually a therapist brought it up. We're like, oh, well, we haven't ever seen that before. And then started looking and it's like, oh my gosh, this has been on the books since 2018. Who knew? So interesting. And questions come up. What if the provider, so I'm assuming this is referring to referrals. So what if the abortion provider is licensed in both Idaho and Washington per se, or Idaho and Oregon? I would just make sure that you're referring them to the provider that is located in another state, because if they're performing the act in Idaho, it's still going to be illegal.
Yeah, there's another question. So just to clarify, no, it's not abortions prior to 2018. The law has been in place since 2018.
Yeah, sorry, I should have clarified that. It was enacted in 2018. And will we be liable if we discuss the option of abortion with the patient? No, not at this time. That's not in the rule now, unless it would be considered aiding and abetting because you're referring them to a provider in Idaho. Again, other states like Texas have a much more extensive rule on this, and it includes aiding and abetting within the statute. If Idaho goes there, which they may this next legislative session, then this is all going to change again. But for now, it's not illegal to discuss with your patients and refer outside of Idaho.
So the other law is the No Public Funds for Abortion Act, which probably doesn't impact a lot of you, but for those that it might, just to be cognizant of it, basically, if you're a certain provider type that receives state funds, you can't provide, perform, or induce an abortion except when the mother's life is endangered by a physical disorder, physical illness, or physical injury, which really becomes not as applicable if the new law goes into place, because it will prohibit that anyways.
And this isn't referring to your Medicaid patients. So even if you accept Medicaid, this is not, there's a call out for that, right, Hannah?
Yep.
Yeah, it's just like if you get a county grant to provide women's health services, you can't use those funding, you can't use those funds to perform abortions.
Yep. So I think I don't see any other questions about that.
There's one, right? Okay, yeah.
Is it true that now, since it's a criminal statute, other criminal aiding and abetting would apply? Not if there's no crime being committed in Idaho, right? If you're referring to other states where it's legal, there would be no crime. So you wouldn't be aiding and abetting a crime, since no crime would occur. If you were referring within Idaho to someone that was doing them illegally for reasons that didn't qualify under the exceptions, then that could be an issue. But as long as you're not doing that, you should be okay.
And also note, like, this is just our interpretation from the information that we have right now. I mean, we're just looking at 2 statutes plus this other one that's in a different part of the criminal code. There's no case law on any of this yet. So that answer may change if the court says something different, but that's what we have right now. So another question. So to clarify, if I see someone with retained products after an abortion elsewhere, I'm obligated to report this? Yes, you are, to health and welfare under Idaho Code 399504. You report this to the Department of Health. So it's worth taking a look at, because it's been on the books since 2018. That's been the rule since 2018. If a patient comes to you and like with a missed abortion or a partial abortion, and you have to treat that patient for those circumstances, then you are supposed to report that for their research. That's what the department says is the purpose of that. How does the federal law view this with EMTALA jive with the Idaho ones? So they've come out. It doesn't really apply to every primary care practitioners or OBs. It would be in the hospital setting, in like an emergency setting when EMTALA applies, and that you must treat the patient. So they can't completely ban abortions. This would maybe not be the case in Idaho, because we do have an exception for the life of the mother. But in states where there's no exception for the life of the mother, where it's a total abortion ban, then they would have to treat the mother if she was dying and have to abort the fetus, if that was the only means possible. Is that what you understood, Hannah?
Yep.
Okay.
We have another question about, does the mandatory reporting apply to abortions performed out of state? And it appears to how under the statute as it's currently written, it just requires the identification of the physician who performed the abortion in the facility where it was performed. So it doesn't make any reference to being in Idaho.
Yeah, it applies to every hospital, licensed healthcare facility, or individual medical practitioner. It requires them to shall file a report with the department regarding each woman who comes under the hospital or healthcare facilities or practitioner's care and receives treatment for these abnormal or deviant processes resulting from an abortion.
Folks, go ahead, keep putting your questions in there, but let's go ahead and move on, Hannah and Caitlin, to what to do next.
Okay.
So this is where a lot of the questions have come up. This is the slide we put together just sort of on our current understanding under the laws of like what's still in the clear, what's a little bit unclear, and then the things that you should not be doing unless one of those exceptions, so rape, incest, death of the mother, apply. So under the statutes, it's clear that birth control pills, IUDs, counseling, and treatment for miscarriage and missed abortion are still appropriate. Referrals, we feel are clear, but again, just because as Caitlin was saying, it hasn't been interpreted and there's no case law on this yet, a little bit more in the yellow zone. Plan B, the laws don't seem to contemplate that being considered an abortion. Prior laws don't seem to contemplate that being considered an abortion, but just because, again, it hasn't been interpreted, it's a little bit more in the yellow zone. Abortion of an ectopic pregnancy, if you can reasonably determine that the mother's life is at risk, it's probably okay, but again, hasn't been interpreted. Chemical abortions, DNCs are not okay unless one of the exceptions apply. And then, like we mentioned, there's no exception for if the fetus isn't viable or has a lethal anomaly, excuse me. So just sort of an overview of that. We'll get into some of that a little bit more in depth in the next few slides.
And you see there are a couple more questions there.
Yes, so we'll get into, so records release, is that actually right? We'll address the records release in just a minute under our HIPAA slide, but the next question was miscarriages can have heartbeats. So is that still safe with Senate Bill 1309? If the fetus did have a heartbeat and then no longer does and is no longer living, then I believe then that is then the abortion or the DNC is appropriate. If it still has a heartbeat, then no, not under the fetal heartbeat rule, and not under the other rule either, unless the mother's life's in danger.
Yeah. So the fetal heartbeat rule defines fetal heartbeat as embryonic or fetal cardiac activity or the steady and repetitive rhythmic contraction of the fetal heart within the gestational sac. So if that's still happening, you need to wait for it to stop.
Right. And again, another question about ectopic pregnancies. That's a call for you as a provider, because whether it's the mother's life is at risk or not. I mean, what I've been hearing, like I said, is that a mother's life is always at risk if there's an ectopic pregnancy, no matter what stage it's at. And if that's the medical training and knowledge you have, and that's what the community standard is, then that's what you should go with. If that's not, if some say you have to let, an ectopic could potentially be viable if it has implanted in the right place, even if it's still not in the uterus. I'm not a medical professional. I don't know that answer. I mean, the law certainly doesn't discuss it. So let's start with the FAQs.
Yeah, so the first question that we've received a lot that we've touched on a little bit is our out-of-state referrals allowed? In our interpretation as it stands right now, based on what we know, is that yes, they are still allowed. There hasn't been a whole lot of guidance given on what's appropriate to say and not say. I think the safe path would just be providing the patient with the name, address, phone number of that referral and not really helping coordinate. But there hasn't been
like
any
transportation.
Yeah, on what is appropriate and is not appropriate to say. So I think sticking with, the information they need, but not helping coordinate it is probably the safest bet at this point.
Okay.
So abortifacient drugs, if a medication or chemical abortion, if it's a medication or a chemical abortion, does that change anything? No, it's still considered an abortion under the definitions. It would be a violation of the rule. Can drugs that may cause abortions, like a side effect, that maybe an abortion, can those still be used for other purposes? Or can the abortion drugs be used for other purposes? The answer is yes. There is an intent portion of the abortion statute, right? You have to intend to cause the abortion. If you're prescribing a drug where the side effect may be an abortion, or abortion occurs, but that's not why you were prescribing the medication, then that likely would not be considered an abortion or anything illegal under 1385 or 1309. And additionally, we've been getting a lot of questions about pharmacies. Will they still fill these prescriptions? Where can we send them? And the answer is yes. So last week, HHS put out guidance for pharmacies and said that pharmacies can't discriminate against customers, including making a determination regarding the suitability of a prescribed medication for a patient. So if you are prescribing misoprostol and the individual goes to pick it up at their Rite Aid, the pharmacy doesn't get to then inquire at this point why they're using that medication. That may change, but that's the rule. That's what HHS has signaled for pharmacies that get federal assistance, and that includes that take Medicaid and Medicare insurance. So I'm assuming most pharmacies do that. So this applies to every pharmacy that you're going to be sending your prescriptions to.
Okay, patient scenarios.
So a few questions about patient scenarios that we've received. What about when the patient has a miscarriage? Can you perform a D&C? Yes, because the definitions of abortion mean terminating a pregnancy and causing the death of the unborn child. So if the fetus has already passed and is no longer alive, it wouldn't qualify as an abortion under the definitions. Another question is, what if the fetus isn't viable or has a chromosomal anomaly? Like we mentioned, under the Idaho laws, fetal viability, it doesn't matter at this point. So the focus is more on the detection of the fetal heartbeat and less on whether or not the fetus is viable. And then, like Caitlin mentioned, selective reproduction procedures would no longer be allowed unless the mother's life was at risk.
Next slide, I think, is the HIPAA and PHI. Is it?
There is a question, and I don't know when you guys want to address this, about mothers and their criminal liability.
There is a statute on the books about mothers' criminal liability. We didn't discuss it today. Do you know what?
It is, let me just pull it up. It's 18606, and it says, it basically makes it a crime for someone to induce their own abortion. So if a mom that's, not a provider and induces her own abortion, she could be held criminally liable.
Yeah,
So,
every woman who knowingly submits to an abortion or solicits of another for herself the production of an abortion, or purposely terminates her own pregnancy that otherwise would have been a live birth, shall be deemed guilty of a felony.
Okay.
and anyone that's an accomplice to that as well could be liable.
And then your next slide, FAQ, is on birth control.
So like we mentioned, birth control IUDs are still allowed because the definition excludes the use of them and the use of medical devices and medicines that inhibit or prevent ovulation.
If it's being, so that it came up last week in one of our discussions that IUDs could potentially be used as emergency contraception. And if that is not the common usage of it, but if it is being used in that manner and there was already an implanted embryo, then it potentially could violate the rule because it's not under the exception of preventing implantation of a fertilized ovum like it like it calls out under the abortion definition.
Yeah, but we've had this conversation with several providers that if it's that early on, you wouldn't necessarily be able to diagnose the pregnancy or know that it was an embryo. So
right,
a little bit of a gray area.
Yep.
There's another question there. What if not performing selective selection of an embryo leads to the demise of other embryos? And has the state not forced the physician to commit murder in that circumstance? I think the question really though is, you know, if the success of one embryo depends on the elimination of another, is that legal in that instance?
Not right now.
Yeah, no, because it doesn't, this laws don't contemplate the viability of the fetus.
It's only contemplates, we only terminate based on the mother's life or rape or incest. Is anyone an accomplice? If anyone is an accomplice, could be liable under 18606. Can we counsel patients about online access to medicated abortions? Again, if it's out of state, I don't know. Right now, we don't believe that the aiding and abetting rule comes into play, and that you could counsel a patient and refer them out of state. Is that what the question is getting at? You can.
The way I read that question, Caitlin, is if it's a if they're using a prescription for an abortion and then they're counseled to go get that and then they self-administer.
Right. My understanding is those drugs you have to have a prescription for. So if you're writing the prescription within the state for an elective abortion, then that would violate the rule. If you're not the one writing the prescription and you're telling them how to go get the medication.
I think that under 605, the provider that's writing the prescription who's not licensed in Idaho, but is writing the prescription to a woman in Idaho could be liable. But it's really not clear at this point because that hasn't been something that women have, had to do until this point.
Next slide is HIPAA and PHI.
HIPAA. So under HIPAA, can providers provide PHI to individuals, including law enforcement, where the law does not allow it? So basically, one of the big fears was, say law enforcement shows up at your clinic and says, show me all your abortion records. They can't do that without a court order. It's not an exception to the HIPAA rule, like the emergency rule. That came out, HHS released guidance a couple weeks ago that an abortion is not an exception to the need for patient consent for disclosure. I don't know if I articulated that very well, but basically, so if an individual goes into an emergency room in a hospital, say an MA in the hospital suspects that the individual may have had an abortion and calls the police can't come in and demand access to those records without a court order. There's no HIPAA exception to that, like that a crime is imminent. That's not an exception that HHS would allow.
So we received a question about whether or not giving contact info to a patient for an organization like Northwest Abortion Access Fund, which provides assistance with funding and transportation for abortion care, would be allowed. I think that it's not totally clear. If you receive federal funds, I would be wary of doing it just because the best federal guidance that's out there is Title 10 guidance, and it restricts you from doing anything really beyond providing the name and the contact information and the address. I think that if you don't receive federal funds, it's a bit of a gray area. It really is what you feel comfortable doing until there's more information and more guidance out there on this. The way I interpret it, it's not strictly prohibited, but.
Right. There's a question from early on about malpractice insurers covering criminal charges. This is a tricky question because if it becomes illegal in Idaho, then it's no longer within the scope of your well, unless it's for an exception, right? Life of the mother, rape or incest, it's no longer within the scope of your practice in Idaho, even though you're trained on it, and even though it is within your scope of your practice under your license in another state, like it's part of your medical training. It's not permitted in Idaho, so I would think that malpractice insurers would use that as a way to deny coverage if you performed an elective abortion without an exception. Some of the things that we've heard so far on signaling what could happen the next legislative session, on rules in Idaho getting more strict. They said that they are going to push hard to, different advocacy groups have said that they're going to push hard to get rid of the rape or incest exception, which will be interesting. Other states have done that too, and have like only the life of the mother exception to abortions. And but we'll see if that happens.
Well, thank you, Hannah and Caitlin. A really heavy topic. You are available. Our next slide says, how can Smith Malek help? And Hannah and Caitlin are available to answer questions if you have staff, or if you yourself want to reach out to us, you are more than welcome to reach out to us at the website there, smithmalek.com. Those are our individual emails. And of course, you can always call us at the phone number given there, 208-215-2411, and it's smithmalek.com. And those are our emails. So please feel free to reach out. We do want to thank the Idaho Medical Association for working with us on this to get this information out to the members of the IMA. And hopefully we get to work with the IMA again in the future on something that is a little less heavy. And we look forward to that opportunity. And do reach out if you have any more questions.
There's a couple more questions.
Yeah, go ahead. We
in
can
here.
keep answering questions.
Would there be any defense if you thought in good faith you were saving the life of mother? Yes, I think so. And like I said, it's all about documentation. If you can document that the abortion was necessary in order to save the life of the mother, not for a mental health reason, because they carve out that exception, then you can perform the abortion without any criminal or civil liability. The next one is, can you talk a little bit more about why Plan B is in the yellow? Hannah, do you want to talk about that one?
Sure, just because the definitions are not consistent. It doesn't seem like the legislature has really gotten everything on the same page yet. So there are some statutes that specifically call out Plan B, and then there are some, like the new statutes, that don't as specifically call out emergency contraception. So again, the way we interpret it is that they weren't intending to include Plan B, but they've not remained consistent through their definition. So it just is, again, until there's more guidance and things have been hashed out a little further, just not crystal clear yet.
All right, with that, I don't see any more questions. Hannah and Caitlin, thank you again. Again, a heavy topic. This recording will be made available both on the Smith Malek website and on through the IMA. They'll be pushing it out. And I believe it'll be available on the IMA YouTube as well. So there is access to this if you want to rewatch it or send it on to anybody that you think would be would benefit from that. So,
do we think the Attorney General will rule on any of these ambiguities?
That's really a legislative question. I think it'll be the legislature that has to clarify that, or the courts, but the Attorney General doesn't have the lawmaking authority. So, sorry to jump in there. All right. Thank you, everyone. Have a great night.